Good morning, everyone, and welcome to the quarterly meeting of the Domestic Violence State Coordinating Council. My name is Brooke Huppenthal, and today is Friday, September 13th, 2024. It is approximately 10 a.m. Central Time. And just as a reminder for everyone, all of our meetings are recorded and housed on the Tennessee Coalition's YouTube page. And welcome to all of our guests this morning who usually aren't with us. And a special welcome to our newest member, State Representative Mary Littleton, who had replaced Representative Andrew Farmer. And I don't believe that she is here today, but we are very excited to have her on the team. And if we could go ahead and call the roll, Secretary Fox will do that. And just as a reminder, please unmute yourself. Let her know that you're here by saying here or present.
Very good. Thank you, Madam Chair. Good morning, everyone. For our guests, if you have not put your name and your agency's name in the chat section for us so that we can record your attendance, it will be greatly appreciated. The roll call, Vice Chair Melanie Bean. She did acknowledge that she will be a few minutes late and she is entering the room now. Council Member Castillo Young.
Here.
Thank you. Councilmember Curtis. Councilmember Chelsea Curtis. Councilmember Dalton. Councilmember Angelita Dalton. Councilmember Davis. Councilmember Dorisha Davis.
Here.
Thank you. Councilmember Davis. Councilmember Sarah Davis. Councilmember Frog.
Here.
Thank you. Chair Huppenthal. Very good. Thank you. Councilmember Jones.
Here.
Thank you. Councilmember Littleton. Councilmember Mary Littleton. Councilmember McDevitt. She did acknowledge that she would be running a little bit late. Councilmember McMillan.
Here.
Thank you, sir. Councilmember Miller.
Present.
Thank you. Councilmember Parker.
Here.
Thank you. Councilmember Reynolds. Councilmember D. Reynolds. Councilmember Reeves. Councilmember Kendra Reeves did acknowledge that she is on vacation. Councilmember Russell. Councilmember Sheriff Ray Russell. Councilmember Scott. Councilmember Jenny Scott.
Present.
Thank you. Councilmember Tate. Councilmember Elena Tate did acknowledge that she had a conflict in scheduling this morning. Councilmember Van. Councilmember Bobby Van. Councilmember Bess.
Here.
Thank you, sir. Councilmember Wiley. Councilmember Page Wiley did announce that he had to take his wife to a doctor's appointment this morning. Madam Chair, that concludes the official roll call, and I am present, obviously, as well.
Thank you, Secretary Fox. Do we have a quorum today?
Yes, ma'am. We do have a quorum. A quorum is reached when we have 7 members present.
Thank you. I appreciate it.
Tina, I have logged in. This is Melanie Bean.
Councilmember Bean. Thank you. We did acknowledge that you were going to be running a few minutes behind, Councilmember Bean, so thank you for letting us know. And it does appear that Councilmember Curtis, Councilmember Chelsea Curtis is present. Is that correct, Councilmember Curtis?
Hello.
Councilmember Curtis?
Hi, Tina. Can you hear me?
Yes, we can. We're just doing the roll call, acknowledging that you're present this morning. Thank you.
Present. Thanks.
Yes, thank you. All right. Thank you,
Thank
Madam
you.
Chair.
Thank you. Secretary Fox had emailed the minutes from our last meeting on September 3rd, 2024. Does anyone have any corrections to those minutes? If there are no corrections, those minutes are approved as distributed. And now we will move to the committee reports. First, the executive committee report. I'm going to go ahead and give that. Members of the committee met on Friday, August 16th, 2024 at 11:30 a.m. And we discussed and approved today's agenda. We also received some concerns regarding different BIPS programs, and we will allow Stacy Miller, who is the chair of the Certification and Monitoring Committee, to speak on those matters in more detail during her report at the appropriate time. Also, as an update, as everyone knows, we've been talking about it for quite some time. Tennessee has a new GPS law that went into effect on July 1st of this year. And it's called the Debbie and Marie Domestic Violence Production Act. We have someone who is here with us this morning, Leonard Belmars. He's the state director and judicial liaison of the Tennessee AMS, who will provide us with an overview and updates on the law. So please, everyone, welcome Mr. Belmars. Thank you.
And thank you. And I have Brent Leonard with me as well. He's our executive vice president. So he'll kick us off here with a review kind of the technology, and then I will go through the law. So Brent.
Absolutely. Good morning, everybody. Thank you again for having us. I appreciate it. Tina, if I'm to understand, if I were to share our slides, just hit share here. I'm imagining and hoping. Bear with me as we. All right. Can everybody see the slides that we just brought up? Fantastic. All right. It's wonderful when technology works. Well, again, thank you. Yes, as Chairwoman said, we've got a new law in Tennessee. Leonard is going to go into a little bit more detail about the legal structure, the code of that. I'm here just to add a little bit of information about the technology itself. So Leonard, do you want to introduce yourself briefly?
Yeah, my name is Leonard Belmaris. I'm the state director and judicial liaison with Tennessee AMS. I have been an attorney since 2012. I was elected judge in White Bluff Municipal Court, which is a municipal court with sessions jurisdiction from 2014 to 2022. Got into this arena in late 2022, working with Brent and the company here, Tennessee AMS. So glad to be here and provide a little, background on the law and where we're at now in Tennessee. So.
Wonderful. And I'm Brent Leonard, Executive Vice President of Ohio AMS. I've been working in the electronic monitoring industry, which is what we call, I guess, the grouping of these technologies that are body-worn or handheld devices that are meant to monitor for compliance with court orders. Been working with Ohio AMS here where I'm based in Ohio for the last 15 years, and now working in Tennessee with Leonard and our team there. And basically, our goals for today are to talk about this new law, give an overview of the technology to start. We feel like the law has incredible value to the state of Tennessee, and we hope that there's other states that adopt similar provisions. But anytime we get into a program like this, where we're monitoring people for restrictions on where they can go, it's really important to understand the limitations of the technology. So we really want to just kind of touch on those, talk about some of the best uses and practices of GPS technology. And then Leonard can certainly get into what the legislative changes are and the procedural changes, and then kind of what role you guys play in that. I do know that we'll be conscious of time. It's about a 45-minute presentation. We're going to distill down into about 10, 12 minutes for you. So, all right, fantastic. So GPS really quickly, global positioning system. I mean, these are very basic terms, right? But it is right now a group of 31 satellites that are orbiting or stationed above North America for us. They're monitored by the United States Air Force. So that's the entity that is making sure and ensuring that they are operational at all times. And in the simplest form, these satellites transmit a time-stamped signal that all of our receivers, like your cell phones, your car GPS receivers, can log, and then through triangulation of position can determine where they are based upon that space kind of time relationship. Was used early on for military purposes, and then in the early 2000s, they finally ratcheted down the restrictions on that. So our devices now are extremely accurate, as are yours, consumer grade technologies. As far as it comes to the criminal justice industry, there's a long relationship between location tracking and the criminal justice world. However, there are many manufacturers of these devices throughout the United States and the world. So you've got a lot of options and choices when it comes to who the courts are going to use to do their offender tracking. Service providers like what Tennessee AMS is, and there's others available to the state of Tennessee, are authorized to provide these devices, do the installations of them, the removals, reporting of the data to the appropriate agencies. There are different services and devices based upon certain standards based upon the provider use. Each provider might have slightly different standards. Now with this law, there are some basic benchmarks that every provider needs to meet. Multiple service providers will use a 24-hour call center for immediate notifications of things that occur while not during normal business hours. And now a big provision of this new law was the mandatory offering of a victim notification device or application, which allows victims to be more in the loop as to what's going on with the offender themselves. When it comes to the limitations, though, now we're going to just briefly touch on the limitations of the body-worn device that the domestic violence offender is wearing. Location failure, this is when that device cannot report to the network where it is. They're very rare. Again, we've got 31 satellites that are available to view. It's very rare that the device is not going to know where it is because it doesn't have a connection with the GPS satellites. We are still communicating with the device in this period of time. So we know the health of it, whether the strap is cut, the battery life, but in the location failure, we would not know where it is. Communication failure, this is when the GPS device that is body worn by the offender cannot communicate with the network because there's a cellular interruption. I'm sure you can understand when that would happen as you lose cell signal as you go around rural areas or maybe in your basement. These devices are affected by the same environmental factors that our cell phones are. So those are ones that are a little bit more urgent, given that we don't know where the device is and we also don't know the health of it. So, and then the final one is drift. There's a number of factors that can affect the location sensing of the device itself, meaning we're receiving those GPS signals, but perhaps that signal is degraded or delayed, giving you a slightly inaccurate location of where the GPS device is. So these are all factors, all shortcomings of GPS devices that I think as we're monitoring people for staying away from certain locations that anybody who's a stakeholder in a program like that would need to be aware of. So again, we're really touching very briefly on these. I would say that Leonard and I are always available to answer more in-depth questions and make this particular publication available to you. I feel like it's really important for you all to have in your hands from the APPA, incorporating location tracking systems into community supervision. It really does a good job of talking about graduated sanctions and location tracking like GPS as just a tool. It goes into more depth about the need for stakeholder education and managing expectations. So I will, with Tina, make that available so that maybe that can be distributed to you folks. And then victim notifications, as we mentioned, this is a big provision of the new Tennessee law. The best use of this is through a cell phone app that creates a mobile bubble around the victim. And when that mobile bubble that's attached to that cell phone meets up with the bubble that is around the perpetrator, the victim will get a notification. So whether or not that victim is at home or work, wherever they are out and about, it gives them a little bit of early warning as to where they are in relation to their abuser. It also will notify them as to the abusers or the perpetrators location as it relates to more fixed geographic locations. So again, brings a lot more information to the victim so they can take action in coordination with you or whatever action plans they may have. But again, it does require them to have an active cell phone, cell service, that the phone is with them, the mobile device is with them, and that the mobile device is turned on. So there still is some cooperation and action that they'll need to take in order to realize the benefits of these new technologies. And with that, then I will turn it over to Leonard so he can talk about kind of some of the statute changes that will mandate the offerings of this GPS.
Yeah, so GPS is defined and enacted through 4011-150, and then 4011-152 generally has the kind of the meat of it, if you will, or what's required. So it defines GPS as using latitude and longitude. It does say it cannot be an implanted device. The previous statute allowed the device to be carried and now must be worn. So there was at least a little concern that, you know, if you're just carrying the device, you could set it down and leave it at home. So now it must be worn by an offender. There are two sections in the new in 152. There's a may section and a must section. Now both have the same notification procedures, but a GPS may be required for any stalking, aggravated stalking, any offense from Title 39, Chapter 13 that involves a domestic abuse victim, sexual assault victim, stalking victim, or violation of border protection. That's the same as it has been. That didn't change. But the must section is the new section of the code. So a defendant charged with aggravated assault of a domestic assault victim, so that includes serious bodily injury, the use or display of a deadly weapon, or strangulation, is required to have a GPS monitoring device. Other changes in the code, real briefly before we get into the process, but other changes in the code, it requires the provider now to notify the emergency communication center. So that's step one in notification. So we send a call to the 911 center in the jurisdiction so that an immediate law enforcement response can be dispatched. We're also required to notify a law enforcement designee, which is a local resource in the county, that the victim is given their contact information by the magistrate so that the victim knows who to reach out to locally in the county for information. And then 3, we send follow-up reports the following day to usually the district attorney, sometimes an investigator, so that they can follow up with charges or motions to revoke bond. So the process, if a magistrate issues a warrant for one of the offenses, the arresting officer is required to notify the victims of certain rights. And the AOC was tasked with designing a form to give to officers to hand to those victims out on the street. The magistrate is required to discuss with the alleged victim certain rights as well. It includes limitations and includes resources in the community. So the magistrate is really the collection point for all the resources. Out in the field, that seems to be quite a challenge. And the magistrate is required to give the victim an opportunity to give multiple zones or ask for multiple locations, and the magistrate has the discretion to choose which locations are approved or not approved, and to prescribe minimum distances that the defendant must maintain from the location. The consent is required. If the victim does not consent, the magistrate cannot require the victim to provide or to roll in victim notification or to provide any addresses, and they cannot put any sanctions on the victim. It's 100% the victim's right to consent or not consent. If the victim does consent, they can be given a cellular device application or electronic receptor device. The receptor devices are old technology. They may still be out there, but most everybody has migrated to a cell phone device application. And it has to be able to receive the information from the device worn by the defendant. And it's not the GPS locations, it's if they go into a zone. So they're not getting the raw location data of the defendants. They are just notified if the defendant enters one of the prescribed zones. And it's also the proximity of the victim's device. So what we do is we install those devices where we have a written agreement with the court. So it does take a little while to implement. We will send an enrollment link or cause an enrollment link to be sent to the victims so they can enroll in the victim notification app. And then we make the reports to law enforcement, emergency communications, and the follow-up reports to the courts. So that is a very quick overview. Kind of you're rolling this. So the magistrates are supposed to assemble all this data and they're supposed to be able to tell the victims of all the resources in the county. So every organization like y'all's out there that has resources, you know, we would encourage you to discuss that with your general sessions judges. They generally oversee the magistrates or make sure, or your victim witness coordinators with the DA's office to make sure that that information is in the hands of the magistrates. And the statute defines, you know, what information is required to be given to victims. But it's things such as, you know, shelters, counseling, education, childcare, legal representation. And so all those things are supposed to be assembled and given to the victims. So providers that are out there, there are more providers every day. So even since we created this, there are new providers in the GPS world every single day coming into Tennessee. Some of which are coming from other states, some of which where people are just creating these since the new law came into effect. And so, but Scram Systems has providers. There's a link there. You can look up those providers. Other providers in the state are Tracking Solutions out of Nashville, AEM out of Rutherford County. Have both been in the monitoring business for quite a while in Tennessee. And again, there are new providers every single day in the state. So Scram Ally is the victim notification app that we use. We can send you a link to a video and overview of the app that's really designed for victims. There is a link down at the bottom, and we'll send you guys the password here to the chat, so you'll have it. It's password protected. It has more information than we would like defendants to get access to, so it is password protected. So that app, you know, like I said, would download onto the phones of the victim. It'll create a zone around the victim's device, and they'll get notifications regarding if the defendant gets within a proximity of that phone. They also get notifications if the defendant enters a zone like work or school. So it would prevent a defendant from entering a home and waiting for a victim to come home. They've got an alert now that, hey, maybe I shouldn't go home and wait for law enforcement to get there first. And so that's a quick overview again of what's out there. We'd be happy to answer any questions. I have provided my contact information in the chat. So I guess with that, we'll hand it back over to the council. So
Thank you both so much. I know as everyone's learning and more about the law and how to implement it, it's very appreciated. And we appreciate also any feedback on how we can help on our end as well. Does anyone in the council have any questions for our two guests? Oh, Chelsea, go ahead.
Yeah, so I don't know if you guys have seen or if your company works at all in Davidson County, but I know that the Davidson County General Sessions Court judges, I think it was as of like 2 days ago, issued an administrative order advising GPS companies basically how to deal with exclusion zone violations. And
Yes,
they're basically, you know, putting it back on the GPS companies to notify law enforcement and to also distinguish between an emergency and a non-emergency exclusion zone violation. do you all have a policy about this already? Like, because I wasn't sure if this was just aimed at, I know that Bryson Rivers case, I think there was probably a fumble there by one of the bond companies. So I don't know if they're just trying to cover their own butts or if that's like something that most of these companies already have a policy about. I was just curious, like, what your policy is with regards to contacting law enforcement after an exclusion zone violation.
Sure. To be frank, we can operate under the current statute. And so when procedures change from the current statute, we don't feel comfortable monitoring when the procedures are changed so dramatically like they have been in Davidson County. So at this point, we're not monitoring in Davidson County because of that. So we're and how it was described to me by really a 911 director, several months ago, and it makes a lot of sense. We're like a company, like a ADT at your home. So we take the alerts, we report those. Determining whether or not it's an emergency or what the law enforcement response should be determined by the law enforcement officers. So that should be a policy in the police department. We're always happy to provide as much detail or about experience as we can when helping design those policies. For instance, like if there is an active exclusion zone violation, like at a victim's home, we advise that probably should be, lights and sirens. If it was only a 30-second, incursion, so they've already left the zone, law enforcement should look at that and decide, what that response should be. The danger there is if you decide that that's a lethal response and somebody has been harmed and is getting medical attention, then it affects that. So we really feel like that should be a law enforcement decision. And then as far as obtaining the victims' locations and data and all that, that's been by the statute designed that's supposed to be done by magistrates, and Davidson County has also taken that and asked the providers to go out and solicit that and get that information. So that's another, hard departure from what's outlined in the statute. And certainly with the new companies, we feel like that's very dangerous with the new companies that have little to no monitoring experience. The danger is that a company will go in and they'll put a device on someone, not have the victim zones, not have those things worked out. And so we feel like that is dangerous. I know that's a long answer to a short question. I apologize.
No, I very much appreciate it. Because for what it's worth, I mean, I agree with you. I wasn't exactly sure. I'm still not sure how they're going to kind of put that burden on the GPS companies, but I was just curious where y'all were with that. So I appreciate it. Thank you.
Yeah, and
Yes,
just
ma'am.
if I could just piggyback on what Leonard says, I mean, there's certain duties and tasks that just cannot and should not be outsourced to a service provider, and that is determining the response from law enforcement. I don't think any reasonable company would ever be willing to shoulder that burden, and also just morally and certainly our philosophy would be that it is not our position to determine whether or not an emergency. We're not boots on the ground there. We are very much like Leonard said. The role we play is a very informed and informative ADT, right? And you would not expect them to call off law enforcement just because your home alarm stopped pinging. So I think that's a dangerous approach to take, and hopefully with time, and as everybody in the state absorbs this law more, we'll have some reasonable reactions to what the new statute is. So.
Thank you. I appreciate y'all's insight.
Thanks again. We really appreciate it, and I look forward to hearing more from you all in the future.
Yes, ma'am. Thank you.
Thank you all.
All right, so next on our agenda is the Certification and Monitoring Review Committee. As a reminder, if motions are needed during this report or any other report, please identify yourself so Secretary Fox can have an accurate account of who's making them, as well as all of the seconds. And with that, we will now hear from the Certification and Monitoring Committee Chair, Stacy Miller. Stacy, I believe that you are on mute still.
I saw that, Madam Chair. Thank you so much. Thank you, everyone. Thank you for being here. I do have a few things today to go through, so I'm going to try to go through them as quickly as possible. Currently, we have 26 certified batterer intervention programs in Tennessee that serve 65 counties. We had one program this quarter that was monitored for recertification. That was Probation Works in Memphis, serving Shelby County. Probation Works in Memphis, they have not submitted all of their necessary paperwork to Secretary Fox to the new coalition manager system. However, they have paid their $200 fee. A monitoring visit was completed on 7/31/24, and the program is requesting an extension to get that necessary paperwork in by Ms. Fox by October 1st. So at this point, we're not going to ask for a motion to recertify them. We are going to move them to the December meeting, and we will vote on that program then. Let's see. There was an issue that was brought to the attention of the committee. One of our providers was subject to a comptroller's audit over questionable financing. This stems from a housing project that was initiated with the program and the state. The director of that program is here today, Mr. Curtis Bryant. He is here again to, he'd like to go ahead and speak to the council. There has been no criminal charges. There has been no update from the comptroller's office on any direction they have planned to take. This was brought to the committee's attention for us to look at. We have met with Mr. Bryant and discussed this with Mr. Bryant, and he is here today to talk to you. So we will give Mr. Bryant just a few minutes if he is able to discuss with us and make his statement. Mr. Bryant, are you available?
I am available. I am available.
Okay, Mr. Bryant. Madam Chair, if that pleases the council, is Mr. Bryant allowed to speak?
Yes, he can.
Okay, good morning to each of you. This is valuable information. As a batterers intervention program, I understand that our responsibility is for victim safety, and I'm learning. This is new territory for me, but I'm wanting to get all the information I can that we might understand and have knowledge of monitoring services that will give further protection to victims. As far as our program, we're still active. We received a referral from the Davidson County Courts this week, and that's new for us. For the last year or so or more, we haven't received any individuals, but we are still active, and a part of our mission is to provide these services. So I don't know what more I can provide. Is there any inquiry from the committee for me?
So, Mr. Bryan, thank you for joining us on this morning. Madam Chair Miller, if you could be so kind to kind of go into some details to advise the council of the comptroller's report. And Mr. Bryant did send in a request, a public comments request to make comments during this morning's meeting. So if you can be so kind, Chair Miller, to kind of give us some background information so that we can all be made aware of the concern. Thank you.
Yes, thank you, Ms. Fox. On March 24th, the committee received an email from the Office of Family Safety regarding investigative report from the Tennessee Comptroller's Office on successful survivors. and which Mr. Curtis is the director of. The email and report was shared with the Certification and Monitoring Committee at that time, and it was added to our June 14th committee for discussion. Upon receipt of the email, Ms. Fox, the executive, spoke with Mr. Curtis. After we concluded, she had requested that he send his statement to her in writing, which he did. As per the conversation about the state comptroller report, let me assure you that nothing about the report will hinder our efforts to be a successful BIP. The report gave us bad press from a housing project, which our nonprofit did provide shelter for homeless veterans and people with mental health challenges. We were requested by the Tennessee Department of Mental Health and Substance Abuse to provide a housing project to help with this population with funds they needed to spend immediately, and we had a 30-day window. We did just that. We were asked to do. However, we were questioned on how we were able to do it so expeditiously. To also build a new home next door for sale to low or moderate income families. We accomplished our task in time. I am sometimes required to do a lot of things in a short period of time. In this case, it was just a 30-day window to complete the rehab and to finish a new home in which I engaged before the state's request for additional services. This project was completed in 2018 and today is a premier provider in the area code of 37208 community. Not to mention, I was able to successfully complete both projects during drug dealers, drug traffic, and drug infested hostility daily. To the day the neighborhood is quiet, peaceful, and supportive to a population that is desperate need for safe, decent, and affordable place to live. The complex is operating today with success stories as residents. I'm proud of the work that God has allowed me to engage in. Unfortunately, criticism comes with challenging the system on the streets and sometimes in government. Let me assure you that Successful Survivors Battery Prevention Program is healthy and helpful. We continue to provide services to our clients with the expertise, care, and conscientious engagement, having as a primary focus offender accountability and victim safety. Later, after we received that response from Mr. Bryant, we met with Mr. Bryant on August 19th in a virtual meeting with the Certification and Monitoring Committees. Myself, Lana Frog, and Tina Fox was present with Curtis Bryant, as well as the Director of Probation, Miss Janetta Nelson. Oh, excuse me. Miss Janetta was not available at that one. The purpose of this meeting was to get an explanation of his email and a better understanding of the comptroller's investigation. Successful Survivors that was dated February 20th of 2024, signed by Comptroller Jason Mumpower. Copies of the report were forwarded to Governor Lee, the District Attorney General of the 20th District, certain legislators, and other various parties. The Office of the Comptroller of the Treasury investigated allegations of malfeasance related to the Successful Survivors. The investigation was initiated after the Comptroller's Office received notification of potential malfeasance from the Tennessee Department of Mental Health and Substance Abuse. The investigation was limited to select records for a period of time of June 1st, 2018 through June 30th of 2019. The results of the investigation were communicated to the Office of the District Attorney. According to the investigative report, in May of 2018, Successful Survivors partnered with the Tennessee Department of Mental Health and Substance Abuse to obtain a grant from the Creating Affordable Housing Program in the amount of $299,670. The Tennessee Mental Health Substance Abuse Association partners with local entities and subrecipients such as Successful Survivors and invest in projects to assist individuals in finding a safe place to live upon their discharge from mental hospitals or crisis stabilization units. In 2018, the funds that Successful Survivors used for the house located at 1604 16th North Avenue in Nashville, they acquired $199,807.04. The remaining $99,862 in funds were to be used to renovate the property into a rehabilitation house. Successful Survivors made grant funds totaling $42,249.74 for unallowable expenses, primarily including checks written to the executive director for developer fees, donations to the Greater Heights Missionary Baptist Church, and various payments without invoices or receipts. The Successful Survivors BIPS is housed in Greater Heights Missionary Baptist Church, where Mr. Bryant is pastor. From October 5th, 2018 to May 2019, the executive director, Curtis Bryant, issued himself 3 checks totaling $27,000 for developing fees. The executive director told the investigators that he believed he deserved payment for facilitating the property purchase and overseeing the renovation project. Investigators noted that the executive director did not have a contractor or real estate license. Investigators also confirmed that the developer fee payments constitute a professional fee and that grant funds may only be used for professional fees if they are paid to someone who is not an officer or employee of the grantee organization, and thus the funds should not be used for professional services rendered by the executive director. While the payment of the professional fees is unallowable for the executive director, payments made for personal services are allowable if it proves that the expense before payment is made. However, successful survivors did not receive approval for the developer fees. Payments failed to provide with any any written documentation justifying the payment, such as an invoice or job description. Additionally, successful survivors donated funds to the Greater Heights Missionary Baptist Church totaling $4,000. They failed to provide invoices or receipts for 34 payments totaling $9,404 and paid miscellaneous taxes totaling $1,845, grand totaling $42,497.40, including the $27,000 for developer fees. During the meeting with the Certification and Monitoring Committee on the 19th, Mr. Bryan admitted no wrongdoing. He was asked why he didn't notify the designee of the Domestic Violence State Coordinating Council of the investigation, and he advised he didn't know that he needed to report. He understands now the importance of it, and Mr. Bryant was also asked if any criminal charges had been made or pending. He disclosed that he has not been notified of any charges nor has been arrested. If charges arise from the comptroller's investigative report, Mr. Bryant was instructed to make it known to the designee of the Domestic Violence State Coordinating Council. The purpose of this memorandum is for informational purposes to the council only, and to make you aware that the Certification and Monitoring Committee, after being made aware of the Tennessee Comptroller's investigative report, its successful survivors, BIPS, dated February 20th, 2024, did meet with Curtis Bryant, the executive director of Successful Survivors. Mr. Bryant was told of the findings from our meeting, August 19th, and will be shared with you all today at our meeting. He was reminded that all Domestic Violence State Coordinating Council meetings are open to the public and that he could attend to hear any discussion. Mr. Bryant was also told if he wanted to make any public comments that he needed to send to the Domestic Violence State Coordinating Council designee at least 2 weeks prior to which Mr. Bryant has done. The meeting ended at 11:30, and at 11:38 on the same date, Mr. Bryant sent the following public comment request that he was formally requesting to be able to address the Domestic Violence State Coordinating Council concerning the comptroller's report relative to the acquisition of the rehab of the property at 1604 16th Avenue.
Yes, how are you?
Thank you,
Mr.
Ms.
Curtis.
Miller.
Thank you. Mr. Curtis, do you have anything else that you would like to add or address from the statement that I read to the council?
No, not that I can recall to mind. We accomplished our task there in 2018. I think there are some things that I shared with you as it relates to the 30-day window, and checks written to the church were 2-3 months after that. I don't know how they included that in our 30-day window, but nonetheless, we have kept our responsibilities certain for that population of people. We are confident that we did the best thing and the highest and best use of the resources we have been used for that purpose. I don't have any more to add, Ms. Miller, and to the council.
Thank you, Mr. Bryant. Council members, is there any council members that has any questions for Mr. Bryant? Again, for the council's purpose, this is for information at this point only. We wanted to make the council aware, and Mr. Bryant wanted to have his time to address the council. Again, Mr. Bryant, is there anything else that you would like to add?
Nothing more than our services to that population of people who are homeless and veterans who need a place to live does not affect our work with domestic violence perpetrators. We've done that for over 30 years, and we're trying to be a force in that arena. And I appreciate being able to do the work and desire to continue to do the work. Thank you.
Thank you, Mr. Bryant. Council members, again, is there any council members that have any questions of Mr. Bryant?
Ms. Miller, I do. I just want Mr. Bryant to acknowledge that if there are any arrests that come about from this, that he is to notify, as we have indicated in the memo, this body. Mr. Bryant, just want to make sure that you understand that.
Certainly, I understand that.
Yes, sir. Thank you so much. Ms. Miller, that's my comment and a question. Thank you.
Thank you. Thank you, Ms. Fox. Anyone else? Mr. Curtis, thank you so much for your attendance and for, again, being able to respond to us when we have called on you through this matter. I do understand that you have some other issues that are very important right now that you are attending to, and that you broke away from those to come to this meeting today. So if you don't have anything else, we would be totally understandable for you to go ahead now that we've addressed your issues with the council, if you would like to go ahead and dismiss yourself.
Thank you so much. I appreciate your time.
Absolutely. Thank you, Mr. Curtis.
All right. Bye-bye.
I will go ahead and advise the council that there are some other matters that we are also looking at, and we will also hopefully give you a report back in December at that December meeting. All right. With that being said, I have another matter that I want to address with the council and to bring it to your attention. The committee has been working on this, as well as Ms. Fox has kept the executive committee abreast. We have another issue with a program, Lighthouse Correctional Counseling and Mental Health Services. At this time, I will give you a quick summary as best I can. Again, please forgive me. I always feel being the chair of this committee, it's the longest report, and I know how valuable everybody's time is. Percy Ford, the program director of Lighthouse Correctional Counseling and Mental Health Services in Davidson County, was arrested June 20th, 2024 for 2 counts of violation of order protection in Davidson County. On Monday, August 19th, 2024 at 9 a.m., we held a virtual meeting with the certification committee members, Lena Frog, myself, and Tina Fox, along with Johnetta Nelson, the director of Davidson County General Sessions Probation, and Mr. Ford, the owner of Lighthouse Counseling. The purpose of the meeting was to inquire about a letter that Mr. Ford sent to me on July 2nd, Ms. Fox on July 2nd, regarding his arrest on June 20th for 2 counts of violation of order protection. Mr. Ford telephoned Ms. Fox on June 25th, 2024, and advised that he'd been arrested for violation of order protection. He stated he was going through a bitter divorce with his wife, and his wife took out an order. However, he admitted that there was no evidence of violence involved. Mr. Ford had decided to temporarily distance himself from the coalition until the court hearing in July 2024. He was asked to put a statement in writing to Ms. Fox, and the letter, Ms. Fox, are you going to share that letter? Or would you like me to read that letter?
No, I can share that as well. Yes.
The letter was to provide background and clarity regarding his arrest on June 20th for 2 counts of violation of order protection in Davidson County. In August 23rd, I asked my wife of 19 years for a divorce, and things have been more chaotic between us than ever. In February 2024, she attempted to hit me with her vehicle on the street in front of our home. During this altercation, as I moved out of the way, I hit her driver's side door glass, causing it to spiderweb. After this incident, she went to the sheriff's department and filed an order of protection against me to obviously cover herself and spin the narrative she hoped would cause a negative optic for me. Metro Police were called to our home that night, and after their interviews and investigation, there were no arrests made. We appeared in court March 4th, 2024, and the magistrate presiding over the case, I firmly believe, saw through all of this and granted the order for only 3 months. The magistrate explained to me that in Tennessee, there is no burden of proof to someone to prove fear, so she had to do something because she stated she was in fear. The order expired on June 4th, 2024. I returned to the home on June 6th and spent the night there. Since June 6th, I had spent 4 nights total in the home. She called the police on June 19th and reported me in the home. They arrested me on June 20th while I was outside of the home in a cul-de-sac smoking a cigar. The arresting officer stated the sheriff's department had in their system that the order was extended and set to expire December 4th. I was never served of any kind of notice to appear in court on the extension. I was not informed that it had been extended or anything to that matter. I was arrested for something I did not even know existed. Because of what is turning out to be a very hostile divorce, I think it is best to separate myself from the coalition until this case is resolved in court so that no scandal or dishonor is brought to the coalition and can be a distraction from the work we all have dedicated our professional lives to. The aforementioned missive was sent to the Certification and Monitoring Committee on June 25th, 2024. During the meeting on August 19th, Mr. Ford acknowledged that the incident happened when he was not at home and while he was at a cigar bar and lounge. He stated his wife entered the establishment and mouthed something to him. She left and he waited a few minutes and left going to the house. Upon his arrival to the house, he saw his wife's vehicle with her in it parked in the cul-de-sac. He approached the vehicle and asked why did she come to the cigar bar and what did she say? An argument ensued as she attempted to hit him with her vehicle on the street in front of their home. Mr. Ford further expressed that during the attack, as he moved out of the way, he hit the driver's side door, causing it to crack. After the incident, Ms. Ford went to the sheriff's department and filed an order of protection against him. On July 9th, Mr. Ford sent the following letter to Ms. Fox. On the evening of Friday, July 5th, I was informed by phone call from my retained attorney, Mr. Paul Walwin, that all charges against me in regards to my arrest on June 20th for violating the order of protection was dismissed in court on that day. Mr. Ford did not have to go to court on the original court date because the charges were dismissed. He brought to the attention that his wife, Courtney Ford, had been arrested on a domestic disturbance that happened on February 23rd, 2024. And was taken into custody and charged with reckless endangerment with a deadly weapon against him on August 13th, 2024. Probation Director Jonetta Nelson acknowledged that Mr. Ford had shared with her of his arrest and the order of protection right after it happened, as he did with Ms. Fox. She praised Mr. Ford for completing free assessments for the domestic violence courts, as well as the work he does. The Davidson County judges have been made aware of Mr. Ford's arrest and respected his desire to distance himself from the court until the matter has been rectified. It was suggested that Mr. Ford continues to distance himself from the court and the coalition until the complete matter has been resolved. Since Mr. Ford has professional ties with BIPS and domestic violence judges, Ms. Nelson explained that when Ms. Ford does go through the criminal justice process in general sessions, a special judge will be appointed to ensure a fair hearing. She will monitor the outcome of the hearing and we will keep the council posted. Ms. Fox sent a memorandum to the executive committee on September 3rd. And to the executive committee, she received a phone call from Jonetta Nelson, the director of probation of Davidson County, called and told me she had spoken with Davidson County Judge Allegra Walker on August 29th regarding Lighthouse Counseling and the services Percy Ford provides to the courts. The judges have agreed that it's best for General Sessions Court to suspend all services until Mr. Ford's legal matters are resolved. This decision includes all domestic violence classes and the drug-free and alcohol assessments he administers. Mr. Ford was contacted by Director Nelson on Thursday, August 29th, to inform him of the decisions made by the judges. The criminal case was continued until 9/23/24 at 9 a.m. in General Sessions Court in front of Judge Marcus Floyd. However, it's highly likely that a special judge will be appointed. Considering the relationship Mr. Ford has with the General Sessions Court. Of course, that's dependent on the agreement made with the district attorney. The complaint against Mid-South Court Divisions, so with that being said, there are still determinations to be made with this complaint. We do want to, again, see how the criminal case against Ms. Ford plays out. There could be some information that comes out in their divorce. There could be some more information that comes out in the criminal case. And so at this time, again, we wanted to make the committee aware, or the council aware, of the complaint, that we had investigated and interviewed Mr. Percy and had continued to look at the matter. So as we are still determining details of that case, we just wanted the council, to know that. Ms. Fox is sharing on the screen. If you'll look, that is where the order of protection has been dismissed against Mr. Ford.
This is on his wife, Courtney Ford.
And this, correct. The alleged offense happened on February 23rd, and she was arrested on August 13th. Does anybody on the council have any questions? Again, there's just so many details and so much communication. I apologize for having to read that out, but we want to make sure that we had all the details in there to present to you. And if I just sometimes go and explain it off the top of my head, I didn't want to leave anything out. And Ms. Fox was very diligent about her record keeping and notating all the transactions that had happened between all parties. She did an excellent job on the reports as always. And we will keep you abreast and let you know in December an update on that case. Currently, Mr. Percy did not have any persons attending BIP at that time.
Hey, Ms. Miller, I'm not sure Judge McMillan has unmuted. Do you have anything, Judge?
No, thank you.
Good, thank you.
The next is we have a complaint against the Mid-South Court diversion serving Shelby County from a district attorney's office. Ms. Fox sent a memorandum to the executive committee on September 3rd. On August 29th, Ms. Fox received a complaint from the district, an employee inside the district attorney's office regarding a concern of Timothy Lee, the program director of Mid-South Court Diversion, BIP. At the end of the conversation, let's see, the individual had asked to remain anonymous. And so Ms. Fox asked the individual to put their concerns in writing so that we could be fully informed of what the complaint was. And below is the verbatim narrative of the email we received on August 29th at 2:22 p.m. As we discussed, I had some concerns regarding victim blaming comments that Timothy Lee of Mid-South Court Diversions made during 2 meetings I attended. The comments were regarding DV victims' rejection of the GPS monitoring devices his company offers, which could be explained by the size and inconvenience of the devices. He made reference to victims paying defendants' bonds and paying for their DV classes, which seemed irrelevant. A few co-workers got the same impression from his comments. Due to my involvement in the DV advocacy field, my gut wouldn't leave me alone, which led me to ask around about Mr. Lee. I was told by an anonymous but credible source that regarding the BIP through Mid-South Court Diversion, Mr. Lee will teach to the curriculum, but interject his own opinions of victims by making statements like, quote, "These women are calling the cops on you. You know they're crazy. You need to leave them alone," end quote. He also mentioned being affiliated with the Family Safety Center and that his DV classes have to be aligned with the YWCA since he is part of the DV Council, which also gave me pause. I don't think that's accurate because neither have anything to do with BIP classes. Thank you for looking into this matter. Ms. Fox reached out to Mr. Lee on August 29th and asked him to respond, and here's his precise response to the aforementioned date on 3/7 p.m. Thank you for a chance to respond to your concerns. I was speaking as a GPS company, which has been charged with a very difficult task. I take it very seriously. The GPS companies in Shelby County have addressed with the domestic violence team and the judges the difficulties of getting victims to accept the device. A lot of my clients are turning out to still be supported by the victim. So when they hear that the defendant will have to pay for their device, for whichever reason, there may be a decline for the device. Another situation that has raised a lot of that has raised is a lot of women being arrested with the male as a victim. They are very much declining the device. I am not aligned with the Family Safety Center, and yes, the YWCA gave me a letter of support for the program due to my mother previously working in the program when she was alive and the clothes and other donations my program has given. I have never violated any trust that they had in me, as I have been able to do the shelters to do free CPR classes. Again, I saw abuse firsthand in my family growing up. If anyone mistook my words, that's exactly what they did. At this time, I respectfully do not want to be a part of the coalition unless I would have the chance to address the person questioning my integrity by video monitored by Ms. Fox. Thank you for my chance to reply. On September 3rd, Ms. Fox spoke individually with the complainant and Mr. Lee. While talking with the complainant, she declined to meet with Mr. Lee, as well as confirmed she did not want to know, she did not want him to know that the concern was from her. After Ms. Fox spoke with Mr. Lee in detail and disclosed the complaint did not want to be revealed and that he has to accept and respect her decision. During the conversation, Mr. Lee acknowledged that he may have been misunderstood when he spoke, and he recalled making similar remarks as outlined, but they may have been taken out of context. So again, this is not for the council to take action. What this is it gives the committee the ability to be intentional and strategic in our planning and in the development of our programs. And so when these complaints or these matters arise, it gives us as a committee the opportunity to see where our programs need specialized training, where they need improvement and they need development. And it gives us that ability to be intentional in the work that we do in order to groom these programs to become strong, victim safety centered and better accountability centered programs. And so when we take these complaints, we often do take anonymous complaints and comments, and we want to be very proactive, and we want to make sure that we are swift in addressing those and doing what we can to do to remedy and alleviate those situations. So again, we have several trainings that are coming up, and these will be some of the topics that we use with our monthly meetings through the coalition that we have with all of our BIT programs. So we just wanted the council to be aware of that complaint as well, and that we were using that as a way to be intentional in our future training. All right.
Do you need some water, Stacy? Bless your heart.
You know, I told the committee that the council was going to wring my neck for reading 5 pages of notes to you. So I have to say, I apologize to you for being long-winded and having to go through a lot of these details, but I do want every member of the council to know how in detail we are when we investigate these how thorough we are, how quickly we try to resolve and expedite the process. We want to make sure that we're very amicable to survivors that come forward. And we want to make sure that, again, we're doing everything that we can from what we expect from our programs, as well as a committee, that it's based on victim safety and offender accountability. And we want to make sure our programs are held accountable as well. Okay, let's see what else I have. We've got an exciting prospect that in Johnson County and Bradley County that they are currently starting a BIPS program in that area. And then in Scott County also, in Miss Lana's area, they are looking into starting a female batter intervention program. And so they have brought some trainings to the table and made the committee aware of those trainings that we're going to send out to some of the other programs so that they can increase their training and knowledge. Ms. Fox, is there anything that I am leaving out? I am looking at my multiple pages of notes on top of what I read to you. So y'all please forgive me. Is there anything else that I have not covered in today's committee report?
No, I think that's it, and you did well. Thank you so very much.
All right,
Thank you,
Madam
Stacy.
Chair. Thank you so much, y'all. I try to read, and I'm trying to read fast, and so again, when you're reading somebody's complaint, you know, they know what was in their thought process, but I don't. So again, sometimes those words don't come out when I'm trying to read them back to you. So forgive me for that, for any stuttering I did there. Madam Chair, that's all we have as a committee. Thank you very much, everyone, for just taking your time to hear us.
Thank you, Stacy. We really appreciate all of your work on this. And unless there are no further questions for Stacy in the committee, we will go ahead and move on to the Emerging Issues and Order Protection Committee report. The committee had met earlier this morning in a separate Zoom meeting. And if Michelle Consiglio Young is available, she's our chair and she will be providing the report. Michelle.
Good morning, everyone. Well, I feel extremely insufficient following Stacy on her very thorough report. So you do a great job with your committee, Stacy. I know everyone says that, but you really do. Just it's a lot of work. That's a lot of work you had to do on that. Anyway, we did meet, as Brooke said earlier. Our committee met this morning. We had several discussion points that we took up, and there are a couple of things that we deferred to the December meeting, particularly on a couple of form issues. Tennessee AMS, who you heard from earlier, actually brought a suggestion to the committee for a change on the bail order form for abuse cases, but there was a recent case from the not related to their recommendations, which are based on the public chapter 1033 that they presented on, but a separate issue. There was a Court of Criminal Appeals case that came down in late, I think it was in May, that had some comments and some suggestions for the bail order form for abuse cases, and in its inclusion of the no contact order on it. So we are still reviewing that in conjunction with the form and the other changes that were recommended. So we just went ahead and deferred that so we could spend a little bit more time looking at that particular case and also at the public chapter, just because that has just been kind of an ever-changing thing. And as counties and courts are implementing it, we continue to hear various comments about that. So we went ahead and deferred that form discussion to our December meeting, as well as a forum discussion on the affidavit of firearm dispossession in regards to the U.S. Supreme Court case, United States versus Rahimi, because we still are doing a little bit deep dive on that opinion that came out on June 21st in comparing Tennessee laws and just what may or may not need to be addressed on our form. So we weren't quite ready for prime time on that today. So we will defer that for the December meeting. We did have a very robust discussion on public chapter 1033 that was presented on earlier. I know so many of you are involved, whether you're on the bench or with the law enforcement or victim services or whatnot, that the implementation of this public chapter has been a little bit all over the place. So we had a very good discussion. There are so many meetings happening with various stakeholders, legislators on just implementation of it and just the practical realities of the challenges of implementing it. So we the committee echoed a lot of those points, a lot of which are just regarding funding, who pays, the defendant doesn't pay, just actual capabilities of the monitoring companies that are tasked with this, whether there are qualified companies in the various counties. So there are just a lot of factors that we discussed. So I think that will continue to be a topic. I do know that there are many, especially the general sessions judges and others that are meeting to discuss that. I highly anticipate some changes and some other proposals on it come very early in January when the legislature reconvenes. So I think more to come on that, but we had a good discussion on it. The main thing that for this committee that we made sure we looked at were all the bench cards that Ms. Fox had sent out to everybody. And in our review of the bench cards, we did not have any, we have one question, but we didn't have any specific changes to all of them. However, we did have a couple of comments on the firearms bench card, where, and I don't know if anyone else on this committee, this group has had time or looked at it recently. And I know it may have been a while since you all looked at it, but there's one on there that regarding the affidavit of disposition of firearms, where on the Tina, on the firearms bench cards on the second page, where it has the firearms dispossession, and then it has the affidavit, and then it says the penalties. And in the penalties part in red, it says there's no definite time for filing the affidavit, but judges should put a date certain in the order because failure of the respondent to turn in the affidavit of dispossession may result in criminal charges against the respondent. So that part is highlighted in our forms, and then also like in specific counties like Davidson, we do have on there that obviously pursuant to the TCA that you shall dispossess your firearm within 48 hours of the issuance of the order of protection. But on the AOC form, as well as in the Davidson County forms, it does say that the court clerk, that you fill out the form, file it with the court clerk within the time frame that the court does provide, which is referenced there. But it also says, please do that, within 1 business day of surrendering your firearms. I don't know if, I'm not sure the genesis of that comment being on the form. Tina, maybe you're pulling it up on the bench card. It's not technically wrong. It is just that we have a little bit of a difference on the forms versus kind of what it says there. So I don't know if anyone wanted to weigh in about that, but that was just a comment that we had within our committee discussion. But I do know that, some courts do use that, 1 business day, and just having that on there after the 48 hours with reasons for show cause and whatnot. So I don't know if we want to clarify anything or leave it as is or maybe make that at all, but that.
Michelle, I don't know that I have anything to offer. I use the 48-hour language in my orders citing that. And then my clerks have a process where they look, when they take the respondent over to the counter to serve them, they give them the firearm disposition form that day and tell them to get it back. They usually set a compliance date that is 30 days out, because it takes some time, on a Thursday, trying to find somebody to take weapons and store them and everything else over the weekend, they may need a little bit longer time. But we leave language in there, and we do tell them that it is potential for contempt if they do not comply with the order and file it back. Not that we're seeking to do it in 48 hours, but that's why they have the 30-day compliance report. Then I get them and see who hasn't filed the affidavit within 30 days, and then we send out a notice that says we haven't gotten it yet. We were serious about that. And usually that takes care of it. Just if that helps, how that card would be used or reviewed by me, that's what we do with it.
Perfect. Yeah, thank you. That's similar in Davidson as well. Like I said, the language on here is not wrong. It's just that some counties have different processes of how to handle that. So I don't want to box anyone in or just put, that with them no definite time on there when there is usually a time frame. It just may, the process may vary just a bit. but that was our comment on that. And Tina, I guess we, you and I can talk, a little bit offline if we need to, change that a bit, but that was the main commentary, when we had looked at the bench cards from our group. And then that is my report.
Madam Chair, if I may, and Michelle, I'm just clarifying, because we do have to get the council to approve these bench cards before the coalition prints these. And so are you implying that we need to tweak some information on the firm's dispossession piece?
We didn't have specific change. We just wanted to highlight that, but I mean, if it would be amenable to the group, it may be, I don't know, maybe more clear if that portion was either taken out or even just the first line, like there is no definite time for filing an affidavit, even if that was removed, and just say, judges should put a date certain on the order. I think it's just that there is no definite time frame for filing an affidavit may lead to a little bit of confusion, because some of it's, like Judge McMillan said, I mean, there is a process, and a lot of times a time frame put on there within the various courts. So just off the cuff, I mean, that would be maybe the suggestion, just take out that one beginning phrase there.
So your suggestion is to take, there is no definite time for filing the affidavit, blah, blah, blah. Is that what you're asking specifically about? We just need to make sure.
No, you don't have to take up the whole thing. I was just saying, to make it not confusing, maybe just take out the first phrase. There is no definite time for filing affidavit, comment, and then just start with judges.
Okay, so let's do this then, if it pleases the council. And Michelle, if you could send me the exact language that you would prefer there, so that we can make sure that we get it the way it needs to be outlined.
Yeah.
And with that, are there any other further discussion points we need to cover?
No, that was it. That's all that we had for purposes of discussion in this meeting.
Thank you. And Secretary Fox, is there anything else that you want to cover?
Yes, we do have to, with that modification, if it pleases the council, we do need to make a motion and get an ultimate vote so that we can get these bench cards printed and get them back out into the public.
Okay, do I hear a motion to approve the amendment to the bench cards?
This is Stacy, and I make said motion.
Melanie, I'll second.
It's been moved and properly seconded, and with that, Madam Secretary, we are ready for a vote.
Thank you, Madam Chair. Councilmember Bean.
Approved. Aye.
Thank you. Councilmember Castillo Young.
Aye.
Thank you. Councilmember Curtis.
Aye.
Thank you. Councilmember Derecha Davis.
Aye.
Thank you. Councilmember Frog.
Aye.
Thank you. Councilmember Huffinthal.
Aye.
Thank you. Councilmember Jones.
Aye.
Thank you. Councilmember McMillan.
Aye.
Thank you. Councilmember Miller.
Aye.
Thank you. Councilmember Parker.
Aye.
Thank you. Councilmember Scott.
Aye.
Thank you. Councilmember Vess.
Aye.
Thank you. And Councilmember Fox, aye.
Okay, and with that, the motion is approved. So we can move forward on the bench cards. And unless there are any further questions or topic points we need to discuss, Thanks again, Michelle, for your report, and we will move on to the training and education report. We will hear from the co-chair, Ashley Parker.
Good morning. Councilmember Fox, can you share the training list that you have? Thank you. So as of July 10th, 2024, there was an advanced DV training CPS at the CPS Academy, and there were 21 participants. On July 11th, BIPS overview regarding Memphis DSV Council, there were 17 participants. On July 24th, there were four different workshops with the DCS Domestic Violence Group. There was a Domestic Violence 101, a safety planning risk assessment, and a trauma-informed care, and a BIPS overview. There were 41 participants for each of those. On 7/31, the BIPS program directors and facilitators met regarding the new GPS monitoring law. There were 67 participants. On August the 28th, BIPS program directors and facilitators regarding the DBSCC standards and rules. There were 21 participants in that. On September the 11th, 2024, the orders of protection, there was 135 participants in that one. And then on September the 12th, there was another DCS workshop in Knoxville. They again did the domestic violence workshop, or the domestic violence 101, safety planning and risk assessment, the trauma-informed care, and the BIPS overview. And there were 27 participants in that. There were 533 participants in all the combined classes. And that's all I have.
Thank you, Ashley. We truly appreciate your report and your work on the Training and Education Committee. Does anyone have any questions? Okay, we'll go ahead and move on to the Standard and Rules Committee. Our chair, Sarah Davis, is not available, so I will go ahead and do the report. The committee met on Friday, August 16th via Zoom. Our standards and, the committee made several adjustments to the rules and specifically the committee adjusted the personnel and training standards to cover program directors because it previously had only covered facilitators, instructors, supervisors, and interpreters. And this related to persons who were accused of DV or had an order of protection placed against them. And as we had discussed earlier, as Stacy had discussed, this related to several complaints that we have received over the course of the last several months. So where personnel face these types of accusations, the rules allow the council to investigate the complaints, and we have added language that authorizes the investigations to apply to all personnel, not just those that are client facing. The committee also discussed increasing fees for certifying program directors. The current fee for certification and recertification is $200, and it's been the same since 1999. The committee discussed increasing this fee and making the cost to recertify different than the initial certification because there's a significant difference in paperwork for the time to complete. The committee updated the fees to $400 for certification and $300 for recertification. During the next meeting, the committee intends to discuss increasing the hours for annual training. And finally, Kathy announced that she's leaving the Office of Family Safety. Heather Herman will take her place and will also serve on the Standards and Rules Committee. And with that, does anyone have any questions regarding the rules and committee updates? All right, now we will have announcements by Secretary Fox.
Thank you, Madam Chair. I will be brief, just a couple of notes. Number one, annually, the coalition has to submit to the governor's office the reports of this council. That report has been submitted, which included all of y'all's names. That was submitted to the governor's office July 15th. Also, quarterly, we have to submit a report to the Office of Criminal Justice Programs. We did submit that as well on or by July 15th. The next quarterly report is due October 15th. So to all committee chairs, I need your minutes by the end of this month so that I can include it within the report that I push out to the Office of Criminal Justice Programs. Again, that is the quarterly report. And then finally, as we mentioned several meetings back, that next year, 2025, this organization will be celebrating 30 years since July 1st of 1995. And we would really like to get together and plan something. So if you are intrigued in planning something and or assisting, please let the executive committee know so that we can include you into the planning, because it seems that 2025 is knocking at our door. So just want to make sure that we keep that on our radar. And Madam Chair, I believe that concludes my announcements. Thank you.
Thank you, Secretary Fox. Next, we have public comments. As a reminder, public comments need to be submitted to our secretary at least 2 weeks before the beginning of the general body meeting. Secretary Fox, will you confirm whether we have received public comment requests within the guidelines?
Yes, ma'am, Madam Chair. Yes, we did. In fact, we received a request from Curtis Bryant of BIPS of Successful Survivor. And as you all know, he was able to make some comments earlier in the meeting. And we did not receive any other written comments or requests. And before I get off, if Lisa Bolton, if you could please put your name and your agency's name in the chat for attendance. I think we have all the other guests covered. Thank you.
Thank you, Secretary Fox. And with our last meeting date, it's currently slated for Friday, December 6th. However, Secretary Fox is planning on being out of the country during this time. And I had proposed that we meet instead on Wednesday, December 4th at 10 a.m. Now, please let us know if you have any conflicts with this date. I know we, our entire council body is not present, but please let us know if you have any conflicts with Wednesday, December 4th at 10 a.m. We'd like to make this adjustment. Secretary Fox is an essential member to our council, and she's so helpful in streamlining and running every meeting. And I wanted to make sure that she would be available and help to work around her schedule. And just please go ahead and send us an email and if you have any conflicts. Next, our proposed 2025 meeting dates are as follows. First, Friday, March 14th, 2025, Friday, June 6th, 2025, Friday, September 5th, 2025, and Friday, December 5th, 2025. We will go ahead and send out all these meeting dates so you have them later on as well. Also, we are going to continue doing professional highlights. Please let us know if you are interested in discussing your work, your agency's work, so we can highlight you and your agency during the next committee. Finally, closing remarks. Does anyone have any questions or comments regarding anything that we've discussed during this meeting? And Stacy, I saw your hand. Do you?
I'm going to go super quick. I just, again, y'all know if I see one of our council members, excelling and being recognized, I want y'all to know about that too. So I wanted to let y'all know that on August 16th of this month, Miss Melanie Bean was elected to serve on the 2024-2025 Board of Directors for the Tennessee Association of Criminal Defense Attorneys, and she will lead that organization as president. So congratulations, Melanie. She's very humble and she never touts her own horn. So I definitely wanted y'all to know of that huge accomplishment that she's been able to accomplish professionally. So congratulations.
Congrats, Melanie. It's so exciting. Thank you, Stacy, for bringing that up. I really appreciate it. And we appreciate you and all the work you've done. And thank you again for your report today. Fantastic work. As a reminder, again, all minutes are due no later than Friday, September 27th. Please submit them to Secretary Fox on or before the deadline. So she has that available for the Office of Criminal Justice Programs. Thank you again, everyone, for your time this morning. I know we are right over our time limit. We appreciate you, all the important work that you do for Tennesseans. And this meeting is officially adjourned at 11:33 a.m. Thank you, everyone. I hope